G'day, it's fugitive Australian journalist Shane Dowling from the website and YouTube channel Kangaroo Court of Australia. Now, the Inspector of the National Anti-Corruption Commission, Gail Furness, has handed down her report in relation to the National Anti-Corruption Commission failing to investigate the Robodebt 6 that were referred to them by the Robodebt Royal Commission. Now, I'm just going to read you out Gail Furness's executive summary. I'll do a full article and analysis on the website tomorrow, Kangaroo Court of Australia, and you can read that. Now, the executive summary, while you're listening to this, just remember, a first-year law student would know more about recusal than the National Anti-Corruption Commission based on what the National Anti-Corruption Commission told their inspector when she asked them questions. They were ducking and weaving like no tomorrow. So apparently we need to believe a first-year law student knows more than the Commissioner of the National Anti-Corruption Commission and all the staff, apparently. Now, the executive summary starts off, as Inspector of the National Anti-Corruption Commission, I conducted an investigation into agency maladministration or officer misconduct in relation to the decision of the National Anti-Corruption Commission not to investigate the referrals of 6 persons from the Royal Commission into the Robodebt scheme. The main issue which emerged from the material gathered during the investigation was the actions taken by the NACC Commissioner, which is Paul Brereton, following his declaration of a conflict of interest in relation to one of the referred persons. The NACC Commissioner made a number of declarations describing the interest in relation to that person as a person he knows well, who is well known to me, and with whom I have had a close association. The NACC Commissioner dealt with the declared conflict by delegating the decision as to whether to investigate the referrals to a Deputy Commissioner. I found that, in light of the conflict of interest, the NACC Commissioner should have not only designated a delegate but removed himself from the related decision-making process and limited exposure to the relevant factual information. That was not done. I found that the NACC Commissioner's involvement in the decision-making was comprehensive before, during and after the 19th of October 2023 meeting, at which the substantive decision was made not to investigate the referrals. The NACC Commissioner contributed to the discussion at that meeting, settled the minutes of that meeting, and was involved in formulating the reason for decision and also the terms of the media statement. I concluded that a third-party, fair-minded observer might reasonably apprehend that the NACC Commissioner's involvement might have impinged on the impartiality of the decision-making of the delegated Deputy Commissioner. My conclusion is based on an apprehension of partiality rather than an actual partiality. I make no finding against the delegated Deputy Commissioner. I found that natural justice or procedural fairness required the NACC Commissioner not to participate in the decision-making with respect to the referred person. By participating in the decision-making in the way he did, the NACC Commissioner made a mistake of law or fact. The mistake was as to requirements of procedural fairness, which amounts to an error of judgment rather than a matter of mere procedure. I concluded that the NACC Commissioner engaged in officer misconduct as defined in Section 184, Section 3 of the National Anti-Corruption Commission Act 2022, being conduct that is not unlawful but arose from a mistake of law or fact. These findings about the declared conflict of interest are based on advice provided by the Honourable Alan Robertson SC, former Federal Court Judge, whom I engaged to assist me. His advice is contained in the Robertson report, which is attached to this report. In submissions to me, the NACC accepted the conclusion that the Commissioner's management of his declared conflict of interest involved a mistake of the kind suggested. The NACC accepted that having regard to the very wide definitions of agency maladministration and officer misconduct in Section 184(3) of the NACC Act, it necessarily follows that this mistake falls within the definition of officer misconduct. I also found that the NACC made a misleading statement in its media release, namely that the Australian Public Service Commission had remedial powers and could impose and sanction in relation to the persons referred. In fact, it could not, because 5 of the referred persons were no longer public servants, and the 6th never was a public servant, and the APSC could only impose a sanction on current public servants. I've made one recommendation. In light of the findings and opinions expressed in the Robertson report, which I accept, I recommend that the Commissioner delegate the function under Section 41(5) of the NACC Act, that is, to reconsider whether or how to deal with a corruption issue, namely the referrals from the Royal Commission into the Robodebt scheme, to an appropriate person. The NACC has accepted the decision should be reconsidered by an appropriate person. Now, the bottom line is Paul Brereton can't survive as National Anti-Corruption Commission Commissioner. that's not a minor mistake. That's a mistake a first-year law student would fail the law class if they made a mistake like that. So how can a former judge, a former barrister, or current barrister still, be making mistakes like that? I'll have a lot more to say in the article I'll publish tomorrow on the Kangaroo Court of Australia website. And please make sure you share this video on social media, and please hit the like and subscribe button. And Kangaroo Court of Australia's independent media and publisher website and YouTube channel. And I'm 100% crowdfunded from viewers like yourself. So please support my Patreon account or PayPal account. Other than that, thank you for your time and have a good day.